Cora Henderson at Pitt and Frank Attorneys. Diane sent us an interesting question via email. She says she's asking, can property and homes be sold if the deed is on someone else's name? In someone else's name. Apparently, both the names on the existing deed belong to people who have passed away. There was no will, and no one truly knows who belongs to the home. How does our listener Diane deal with that?
That's a good question, Diane. So, I get those calls from time to time with interested purchasers, but they're just not sure who to reach out to. The home may be vacant, the home may be abandoned, and there's an interest to purchase that home. And certainly we'd like to see those homes get new life for someone else. But if there are no identifiable heirs that are stepping up, certainly, it could be a court action in order to unravel who is qualified to sell the home. So if the current title holders are both deceased, and again, there was no wills, no one can identify who the heirs are, we want to look at a number of different considerations, regarding was everyone noticed properly, et cetera. But in the state of Kentucky, if that's true that there are no heirs available, then under Kentucky's intestacy laws, the estate, including that real property, would escheat to the state. I know that's a mouthful. The estate would escheat to the state. So ultimately it would go to the state and then they could sign off. But again, a court action could unravel all of that and provide further direction. And ultimately, if that's the case, you could motion the master commissioner to try to sell the property on behalf of the state if it escheats to them. But a court action, of course, is going to be costly and certainly timely. So we just don't see a lot of interested purchasers going down that road per se, which is unfortunate, again, because we like to see life being breathed into those homes when things like that happen.
So is there a workaround that will not cost Diane money at this point, or it's really got to hire an attorney and go that way?
I think it's probably, she can certainly reach out to probate court to discover whether or not, this is a valid scenario where it would escheat to the state, and perhaps they can find some or direct her in an avenue that she could go without an attorney. I don't know how that process, would happen without one. And certainly, just like a lot of other court actions, having an attorney helps expedite that. It provides just a little bit more seamless opportunities there. So I think the rule of thumb for all the listeners would be, don't let that happen to you.
Yeah.
And so I think estate planning and having your estate in order, whether you want to do that through a will or trust, is very important. And the legal team here at Pitt and Frank would be delighted to sit down and talk to somebody about what that looks like, so that we're doing the planning in advance and we don't have properties sitting there. And we certainly don't want to have properties escheat to the state if we don't have any heirs.